Hi, I'm Megan Zavieh, and I'd like to just run through a few of my top tips for how to put together an effective investigation response letter. So my first tip is simply take it seriously. The State Bar does. They take it real seriously. So when you write your response, you want to do things like double checking every one of the facts that you allege. If you're going to say that you contacted a client on a specific date, go back to your documents, make sure you have that date right. Just make sure it's all perfectly correct. Even if you're not producing documents, you don't want to later have that statement brought in if you ended up at trial or if you ended up in a settlement conference as evidence that you were somehow not completely candid with the State Bar. And sometimes it can just be used to undermine your credibility if you've made mistakes. So take it really seriously. My second tip is try your best not to write in a defensive tone. So hard to do this, so hard. I know that what I'm saying is a lot easier said than done. But when you get a bar complaint, your natural inclination is to be extremely defensive, and that comes through in your writing. So this is where having someone else read over your response is really important. Have someone read it specifically for your tone in mind and try to filter out the defensiveness. Tip number 3, don't attack the complaining witness. Again, somewhat easier said than done. If the complaining witness was the most difficult client you ever had, who had all kinds of unreasonable demands and expectations, you're going to want to impugn their integrity when you're writing your response. It's hard not to just say, this person was crazy, you shouldn't listen to anything they say. Keep in mind that when the State Bar is reading this, at the moment, they have only the complaining witness's story. And although they do see a lot and they see some crazy clients, so it's not like they've never seen someone who was off their rocker before, the fact is that when they're first reading it, they are looking at it from the complaining witness's standpoint. And your best response will be one that doesn't tear down the complaining witness. State facts if they're relevant. Those facts may go to the credibility of the witness, but don't simply tear them down. Fourth tip, address the fact that there may be privilege issues head on in your letter. Now, if the complaining witness is a client and nothing that the State Bar has asked for remains privileged, that's fine. You can still answer the questions and produce the documents, but include a statement that says that you're doing so because you realize privilege has been waived. If privilege is not waived or there's some issue with it in your response, again, address it. You want to demonstrate to the State Bar that you recognize the issues. And then my fifth tip is to give a complete response. That does not necessarily mean producing every document they request or answering every individual question that they ask you. But a complete response does need to address the situation completely. Now, the reason I make that distinction is that State Bar investigation letters are often from templates, and the lists of documents and sometimes even the list of individual questions don't directly make sense for every case. So, for example, you may have a case where the person was never a client, and yet it will ask you for the retainer agreement. So when I say make a complete response, you're not going to be able to provide a retainer agreement. But you do want to make sure that you're addressing the substance of the requests from the State Bar in their entirety, because that is going to streamline the process. They're not going to have to come back to you and say, we asked you these questions or we asked you for these documents and you never said anything about producing them nor produced them. So make sure that's complete. And there's my top 5 tips for responding to a State Bar complaint.